Here, my name is Damien Grant from Waterstone Insolvency, and I'm here with Brent Norling from Norling Law. And there's a really important issue that Brent and I thought it would be really useful for business owners if we share this information with you. Now, I've got a investment in a company, not my insolvency practice, and we have been affected significantly by the COVID-19 outbreak. So much so, well, to the extent that as a result of the change in the 4-week lockdown, we are unable to use our premises. And so, Brent, I consulted my lease, and in my lease there was a clause that appeared to give me or my company the right not to pay the lease during the period of the stand down. So I referred it to you, you referred it to one of your staff, and where did we get to?
Yeah, so before I launch into that, it's great to connect with you here, Damien. We're using Zoom because that's what you do in the COVID-19 outbreak. It stresses me to have to socially distance myself from you, but we're making it work anyway. So,
look, it's understandable, Brent, you're only human.
So, look, the deed of lease that we're talking about is the standard Auckland District Law Society deed of lease, which is the one that we see time and time again, probably the most common one out there. And this deed of lease allows for some provisions around no access in an emergency. And I've got it here, and I think it's helpful if I read it just a little bit. So what it says is, if there is an emergency and the tenant is unable to gain access to the premises to fully conduct the tenant's business from the premises because of reasons of the safety of the public or property, or the need to prevent, reduce, or overcome any hazard, harm, or loss that may be associated with the emergency, including, I'm going to skip the irrelevant ones, restriction on occupation of the business, the premises by any competent authority. Let's pause there, and let's just assume that the New Zealand government is a competent authority. Legally, I'm sure it is.
For the purposes of the courts, I'm sure it would be.
Yeah. And then if you can tick those boxes, then a fair proportion of the rent and outgoing shall cease to be payable for the period commencing on the date when the tenant became unable to gain access to the premises to fully conduct the tenant's business from the premises until the inability ceases. So to break that down, if there's an emergency and the tenant's unable to gain access to fully conduct their business because of reasons of safety of the public or property, or need to prevent or reduce, overcome any hazard, and that restriction on occupation is by a competent authority, i.e. the New Zealand government, then you don't pay rent during that relevant period. And it's going to be really, really relevant heading into particularly stage 4 of our government's COVID response, possibly stage 3, but we're talking about a 48-hour period, so it's not a big issue. But certainly stage 4, we're being told non-essential businesses stay at home. And so, I think there's a real opportunity here for businesses to utilise this provision. And look, it's not without risk. It's certainly not without risk. Well, the next clause effectively states that there is an ability, say, for the landlord to terminate the lease with 10 working days' notice if they also believe, and the wording here is it that at any time prior to the termination established with reasonable certainty that the tenant is unable to gain access to the premises for the period. And this links back to an earlier part of the part of the deed of lease, and in the schedule there is a no access period that's highlighted here, and on this particular draft lease it's 9 months, and so that clause would be read as, if you can't access it during a 9-month period, then the lease can be terminated. And some leases are going to be much lower than 9 months, and so it really just depends on the specific lease. So I suppose
what does that mean in practical sense? So if we say we can't access the lease for 1 month, the premises for 1 month, is the landlord, and the landlord agrees with that, is the landlord able to cancel the lease in that 1 month?
No, if the period that we've referred to before is 9 months, then no. The period is going to need to be 9 months, and if we reasonably believe that you can't access for 9 months, then yeah, it could possibly be terminated. And look, that termination could be by either party, not just the landlord. But I suppose if you've got a very short period, you probably want to be careful invoking this clause if you intend to continue with the lease.
Okay, so for if the lease, let's say that that period is 6 months. So if this COVID-19 stand down lasts for say 6 weeks, then the landlord is unable to cancel the lease if the mandated stand down period is less than 6 months.
Well, it's not a stock standard answer I can give, because the party that terminates can at any time prior to the termination establish with reasonable certainty that the tenant is unable to gain access during the period. So you don't actually have to wait the full period out, right? It's effectively a forecasting exercise. So how long are we going to be in stage 4 for? I mean, the government currently have said, at least a month, possibly longer.
So, but I understand that. But from a practical perspective, let's be really clear here. The likelihood of a landlord terminating the lease in this current environment is really low. And I think for most small businesses, if you went to the landlord during this time and said, look, I'm simply not able to pay the rent during this crisis, most landlords are probably not going to be happy. But we spoke about this in an earlier video. I think just commercially, most landlords want to support their tenants if they've been a good tenant, and they will understand that they're going to need to make their own provisions with their financiers and other bits and pieces. But I think the other really important thing to point out is, so you raise the fact that there are potentially some complications and some risks. So I think the key thing is, if you are a tenant in this situation and you are contemplating invoking this clause, before you do so, you should consult your lawyer. Obviously, we're not providing legal advice. But I would also say that if your lawyer has not brought this issue to your attention, then maybe you want to consult with a lawyer who has brought this to your attention. And certainly, I'm aware of a very competent one in Rosedale Road, very handsome, even in casual attire as he is at the moment. So look, any other issues before we let people go?
Yeah, I suppose I would just from a practical perspective also add, look, the intention here is really to work with your landlords and to get a situation. Look, there may not be a win-win here, but there might be something that everyone can live with, and out the back of COVID-19, when this is all over, that commercial relationship can continue. So this is just really about everyone surviving, and it's also about to tenants, business owners. I know it's rough out there, and it's really about knowing where your leverage is and the options that you have that you may not be aware of, and you need to pull every lever that you have right now in this environment.
All right. Okay. Thank you very much, and we'll talk to you soon. Bye, Zoom.
All right. Cheers.
Bye.